Now let's have a look at the things we're going to be covering in today's webinar. We're going to start off looking at why you might have a shareholders agreement at all. And we're going to think about how the shareholders agreement works with our constitutional documents. And we will stop and think about what the constitution actually means now. We'll briefly mention whether the model articles are fit for purpose when we have a shareholders agreement. And then we're going to go into detail on the key elements involved in a shareholders agreement. So we're going to look at how the money comes in. We'll talk about share transfers and lots of things connected with share transfers. Some of the concerns about finding a buyer and things to think about when you're drafting valuation clauses. We'll look at good leaver, bad leaver, drag and tag. We'll talk about restrictive covenants. We'll talk about veto rights all the way through. We'll look at service agreements, and we'll look at the end how you might want to take money out of the company as well. So there are loads and loads of benefits to having a shareholders agreement. We've already seen the first one. Commercially, people tend not to file them at Companies House, so they are confidential. It's certain, it's a contract, you all agree the terms, you all know what you've signed up to. And you can build in lots of minority protection within that shareholders agreement, like that long list of veto rights that we've been talking about, and we'll look at in more detail a bit later on. And you can also build in additional things as well. So you can have veto, you can have decision making, you can allow certain shareholders to appoint and change their directors. The drawback, you need unanimity to amend because it's a contract. You need a deed of adherence to sign up any new shareholders, so they're not automatically bound. And a major commercial issue is that you can end up with deadlocks. So for example, if someone is constantly using veto, and you then need to deal with how you deal with those deadlocks within the drafting. And we've also said that there are circumstances that would trigger this process, that would trigger a deemed transfer notice. So there are often very common things that you would include in your triggers for a deemed transfer. So insolvency, mental illness, death, resignation from office, and if they want to leave. And it's inevitable that if you have any shareholder that is an employee, if they cease to be an employee, they must be required to sell back their shares to the rest of the team. You don't want to leave an ex-employee holding shares. So we're going to look at good leaver and bad leaver as well.